The litigation has been unfolding for 5.5 years. It has been a protracted but interesting endeavor, and we are very gratified that Justice Scalia and his 4 colleagues that joined the 5-4 majority adopted, I'd say, many and perhaps even most of the points that we have put forward in our briefs, our written briefs, and our oral argument. And included among those are the key point, the threshold point, that the Second Amendment does indeed secure an individual right to keep and bear arms, and that right does not have to be exercised solely within the context of militia service. It extends to self-defense, it extends to hunting, to provide food for your family, and other purposes as well. Some of these purposes predated the United States Constitution, predated the United States government. They're part of our rights handed down under our common law tradition, and indeed part of our natural rights tradition. So indeed they could not have depended upon the existence of a militia for their application. So that's point number 1. Point number 2, we're gratified that he saw that with such an individual right, the D.C. gun ban could not be sustained. This is a gun ban on all persons, at all times, in all homes, for all reasons whatsoever. And Justice Scalia concluded that such a ban could not be considered as a regulation that could coexist with an individual right secured by the Second Amendment. So the 3 provisions that we challenged were all declared unconstitutional. The first, the ban on handguns. The second, the ban on carrying a handgun from room to room in your own home without a permit, and you can't get a permit. The third, the permission to have rifles and shotguns in your home, but with the qualification that they must be unloaded and either disassembled or trigger locked. All of those regulations have been overturned. Put that all together and you have an opinion that I think we're very happy with. There was this notable fact. We had asked the court to adopt what lawyers call strict scrutiny. There are 3 levels of scrutiny. There's rational basis scrutiny, where the court effectively rubber stamps anything that the legislature comes up with. That's almost no scrutiny at all. There's an intermediate level of scrutiny, what some people call heightened scrutiny, and this is what the Justice Department recommended in their brief. And then there is strict scrutiny, which we recommended. Strict scrutiny allows certain regulations to exist, but if the regulation is with respect to a fundamental right under the Constitution, the government has to jump through a couple of hoops. First, it has to show that its regulation has a compelling reason. And second, it has to show that the regulation will be effective at satisfying the need and is no more sweeping than is absolutely necessary, doesn't trample on any more rights than is essential to accomplish the ends that the government seeks. Now, the Supreme Court resolved this case without adopting any particular level of scrutiny. We would have preferred to see strict scrutiny, but at least the court categorically rejected the rational basis standard. And then it went on to reject an alternative standard that Justice Breyer suggested in his dissenting opinion, which is called a balancing of interests standard. Now, what that leaves us with is either this heightened or intermediate scrutiny or strict scrutiny. We don't know which, and the court won't decide that until perhaps later litigation comes forth. But at least it's a heightened level at a minimum. And for that, I think we're pleased as well.